at this point, we can begin with you, Mr. Kramer.
Your Honor, thank you. Good morning, and may it please the court. It's my privilege this morning to represent Gary Brooks, who is an honest, hardworking lawyer who was so busy doing his job that he neglected to bill for it. Add in a couple of other mistakes, and here we are. But this morning, I'd like to share two key points with you. First, that this record does not contain the type of flagrant violations warranting a suspension from the practice of law. And second, that a less disruptive sanction, that of a reprimand, would protect the public without disrupting the lives of those he serves. It would also better fit the gravity and intent of the infraction and consider the many mitigating factors warranting a much more modest remedy. This is not a case of dishonesty, greed, abandonment of clients, or the neglect of a case, and we shouldn't punish him as if it were. On this record, we see the wisdom of the estate plan that Gary Brooks prepared for the deceased Errol Ellis. Where would we be without all those life insurance policies to pay the debts of this estate? We also have more than ample evidence. Indeed, the record is replete with documents showing that he kept all of the legatees informed of his progress. You look at petitioner's exhibits 11 through 36, and you see innumerable emails to all three, providing a list of exactly where things stood on each item. The problem came down to billing. What he did not do in terms of communication, and Judge Osby found correctly, is he did not communicate where he was in terms of all of the time that he was spending trying to wrap up the affairs of this estate. And his main error was treating legal expenses incurred in administering the estate as expenses of administration. They are not under the Estates and Trusts article. There's a separate lower priority category for them. So his use of $860 in estate funds was not proper. He should have billed the legatees separately outside of the estate. That was the main infraction involved in this case. We have taken issue, I would call the mild exception, to a few of Judge Osby's conclusions. One involves the advice on potential claims. Judge Osby thought that advising the legatees on the unsecured claims, such as the MICU line of credit or the Discover credit card debt, that was not proper, that was improper because they would never reach those unsecured claims anyway. But the petitioner's own expert said that it was a good practice to make them aware of potential claims. So at the time Mr. Brooks advised the legatees of those claims, we had yet to determine what claims would or would not be covered in this particular estate. He even said that the advice on the MICU line of credit was correct and that it wasn't necessarily inaccurate to advise them of the Discover debt. In point of fact, he did not pay any unsecured claims. So there wasn't any infraction in my view on that point. In terms of the payment of certain claims, the expert, Michael Stelmack, called by the petitioner, didn't believe that the respondent paid any other claims out of order. And on the funeral expenses, and I think this is a point that perhaps needs clarification. I've tried to do that in the context of my brief. I'm not sure Bar Counsel really understands what we're saying. Funeral expenses certainly would have taken priority over any legal expense. That's true. But the finding below that Mr. Brooks failed to pay funeral expenses and had a duty to do so, I think is inaccurate. There wasn't sufficient funds in the estate to pay those funeral expenses, which were exceeding $15,000 up to a cap in the estate's article of 15. There wasn't sufficient funds. The only significant asset in this estate consisted of a Corvette valued at $12,450. But interestingly, That was a car that was bequeathed to the complainant, Toria Ellis Dugar, and one that she drove away to her home in Atlanta without paying the estate for. So she actually got the benefit of $12,450. So it wouldn't make sense, as I've stated in our brief, to actually sell the car in order to pay Ms. Dugar the proceeds of a vehicle left to her. She actually got the benefit of that. That's why I say, effectively, my client really did reimburse her to the extent of available assets for the funeral expenses incurred. Expenses, by the way, that were actually paid out of an insurance policy that my client encouraged the decedent to take out. The same was true for the house, for example. There are some errors identified on Schedule B, but predominantly the error that is the gravamen of this case is the confusion of attorney's fees incurred in administering the estate with the expenses of estate administration. He did list the vehicles, he showed the valuation, he listed the funeral expenses. The revised Schedule B is entirely accurate with that one exception. There is also a finding below that there was no fee petition and that there should have been. And I would take issue with that. Why? Because a fee petition would have had to have been denied. We have to admit that we really should have billed the legatees outside of the estate assets. Because if Mr. Brooks had filed a petition for attorney's fees, the Orphans Court would still have to apply the same priority listed in the statute and would have had to deny those fees coming from estate assets. So it's a minor, maybe technical point, but I don't think a fee petition would have been warranted here. In fact, it would have been a filing of a document that would have lacked a substantial factual basis. So to that extent, we've taken issue. But in the main, Mr. Brooks and I, we agree with the gravamen of the findings below. He should have done a better job in managing this small estate. The key, however, is what do we do about it? And I would argue that we need to impose the least disruptive sanction. In this case, a reprimand would protect the public without harming the public, without disrupting the lives of the clients that depend on Gary Brooks. In this case, Bar Counsel was actually arguing for the most disruptive sanction, one that I believe exceeds the gravity and the intent of this infraction. This court has said that the sanction of an indefinite suspension is extreme. As it said in Milton, it's one of the strongest we may order against an attorney. By contrast, a reprimand, this court believes, in appropriate cases, can protect the public and deter lawyers from violating the rules without disrupting the respondent's practice of law. And it's not for the protection of the respondent alone. It's for the protection of the public. If we really want to protect the public, why would we harm members of the public that so directly depend upon the services rendered to them if we do not have to? So this court must balance in this equation the need for deterrence with the impact that a disruption on the attorney's practice would have on the lives of the clients. And if we listen to Judge Hurd, former chief judge of the Circuit Courts of Baltimore City, if we lost the services of Gary Brooks, we would lose an impeccably honest, trustworthy lawyer who truly cares about his clients. I found her testimony to be particularly compelling in this case. This is not an individual who likes to lend her name to vouching for the credibility, trustworthiness, honesty, and character of people. She's a very strong judge of character. And in her view, there are few good Mr. Gary Brookses out there. It would be great if we had more of them, but we don't. And I don't want to see this court take him away from the clients and the community that he serves. This case is replete with mitigating factors that need to be taken into account here. First, this is not a case of dishonest or selfish motive. One of the last things on Gary Brooks' mind was billing for his work. I'm not saying that's a good thing. It's not. We have an obligation to our clients to keep them apprised, not only of the substance of the cases that we're talking about, but additionally, to keep them apprised of what their costs are as we proceed. Gary Brooks failed to do that, and that is an oversight, but not an oversight motivated by greed or dishonesty. In fact, the sum total of all of his work in this case, and you can see from the petitioner's own exhibits, a lot of work throughout this case on a small estate, but still a lot of work needed to be done. He only got $2,168.65 on hourly charges that would have exceeded $5,000 in this matter. He was fully cooperative and honest throughout these proceedings. Bar counsel stipulated to that. And he did make good faith efforts to rectify his mistake. Bar counsel questions whether that's true, but what happened here is that Bar counsel released an expert opinion of Michael Stelmack, an expert on estate administration, on August 28th of 2020. When Gary Brooks received that from me, actually, as his counsel, he took it to his friend Lewin Garrett, who's the chief judge of the Orphans Court of Baltimore City, and they reviewed it together. And he realized that, you know what, Mr. Stelmack was right. He did make a mistake when it came to categorizing the attorney's fees in this case, that he should have recognized there was another separate category for attorney's fees that had a much lower priority under the statute. And so on September 18th of 2020, not long after he was able to obtain and review that opinion, he made a full refund with interest. And this is not an individual who's trying to protect himself in this regard. If you look at his letter, which is Respondent's Exhibit number 2, you'll find that he didn't try to couch it, he didn't try to dodge, he didn't try to minimize. He fully admitted his mistake and in detail admitted his mistake. His own petitioner's own expert would have done exactly the same thing. He testified to that. And my client also made many other changes in technology, changes in reviewing his trust procedures and things of this kind to help prevent any recurrence of this sort of problem. His remorse is beyond question. He recognized his shortcomings, he owned up to it. He was very candid about that with those who testified on his behalf, even saying to them, listen, if you're not comfortable, I completely understand. And people like Judge Hurd, Dr. Freeman Rabowski at UMBC, James Wiggins, many others, Lewin Garrett, the Chief Judge of the Orphans Court, had absolutely no hesitation and no reservation in vouching for a man of absolutely impeccable character. This is a case actually that's reminiscent of the Keating case that we discussed last year. Here is a person, and Judge Osby found, exercised extraordinary efforts on behalf of his clients and the community at large. He devoted his life to improving the lives of his clients and the community at large. Here's a man who was licensed in 1992, but he actually didn't go into private practice until 2004. Why? Because he stayed in public interest jobs. He was working on housing for the poor in Baltimore City. Here's a man who organized a food cooperative so that they could get food at cost, with low cost prices. An individual who served in the cabinet of Mayor O'Malley on these issues, trying to get private partnership to help address some of the problems of Baltimore City. And even after he left that work in terms of his day job, he stayed with public interest, helping the poor, addressing the housing crisis. organizing inner city sports programs that he himself played basketball in one of the programs that he took over, created a charter school, fundraising for minority scholarships at UMBC. Dr. Rebuttal testified that he doesn't know anyone who is more sincere in serving other people than he is. He called him a decent, humble servant of humankind. And Judge Hurd trusts him implicitly and without reservation. In fact, Judge Hurd would be one of those, her family would be one of those clients that would be adversely affected by a suspension as urged by Bar Counsel, because she referred her own aunt for an estate plan to Mr. Brooks. Very pleased with his work and is looking forward to he's probably working on administering that estate now. Yes, he made mistakes, but let's also give him credit for the fact that the estate plan of Errol Ellis really did work and worked quite well. Had it not been for his urging of getting those life insurance policies, here is an estate that would have had far more debt than any of the tiny assets involved. And I understand the legatees, particularly the one, Toria Ellis Dugar, was upset, particularly at the fact that she didn't get a running balance of where she stood in terms of the legal expense on this case. And that often does lead to a lot of client complaints. And certainly that's why we're here, one of the real reasons that we're here. I'm not suggesting that we provide a commendation for this man, but a reprimand would be appropriate. And it has been appropriate in many other cases, in fact, cases that involve more significant problems than we have in this case, cases where actually clients' interests have been neglected. Take, for example, the Scott Adams case, which is at 441 Maryland 590, 2015 decision. Mr. Adams showed incompetence in handling an estate in a manner that harmed his clients. He waited approximately 18 months to file the estate tax return. You contrast that with Mr. Brooks, who got on the administration of that estate immediately, did not waste any time in trying to get that mortgage paid off. Now, it took a while because we had some complications with how the beneficiary was designated M&T Bank, and the bank and the insurance carrier weren't cooperating with each other and things of that kind. It took some time. Sometimes even with small estates, there are complications, but he tackled them. And we've stipulated that he was not in any way at fault for the delay in paying that off. He didn't put the house into foreclosure or risk anything, nothing of the sort. There really are no problems with his substantive work. It's really a question of billing and the money involved here.
I have a question for you.
Yes.
You were going through the mitigating factors, and I noticed in the aggravating factors there was a prior reprimand. Was that related to estates and trusts at all?
To my knowledge, no, although I will say, Judge McDonald, that Bar Counsel did not put in any evidence as to what the circumstances were surrounding it. The only thing we have in the record is that it involved an overdraft notice in the amount of about $6. And this is over almost 7 years ago. So I don't believe it has any contributing factor here. And I should say that, I understand this court may be a little bit more reluctant to impose a reprimand on someone who's been reprimanded before, but there is precedent for doing so. The Tolar case, for example, in which there were 2 prior reprimands on Ms. Tolar. And they were private reprimands, they weren't court reprimands. Similar to the case involved here, we didn't have a full dress opinion discussing the problems, but the court found that there wasn't a need, particularly given some of her pro bono activities and her sincere remorse and the likelihood that it would not be repeated. The court was satisfied that, you know what, a reprimand will protect the public. We don't need to harm a certain segment of that public by disrupting the practice and all of the good that the lawyer could do. And that's particularly why I believe a reprimand would be entirely appropriate in this case. Thank you.
All right, thank you, Mr. Kramer. And it looks as if you got just 2 seconds shy of your 20-minute opening. Ms. Bolts, we'll now hear from you.
Thank you. Good morning, and may it please the court, Jessica Bolts on behalf of the petitioner. This case involves the second instance of misconduct in which the respondent failed to adequately safeguard client or third-party funds, as well as the respondent's complete incompetence and failure, lack of competence and diligence in his administration of the estate of Errol Ellis. In September 2017, the 3 beneficiaries of the estate, the wife and the 2 children, retained the respondent to represent and administer the estate. It was a small estate. There were very few assets, including 3 vehicles and approximately $100 in a bank account. The family home, which was deeded outside of the estate, along with numerous life insurance policies, were all not assets of the estate. The obligations of the estate included the ministerial fees, funeral expenses, and the family allowance. As found by the hearing judge, in September 2017, the beneficiaries paid the respondent $2,500. $2,000 was a retainer for his attorney's fees, and the other $500 was for costs to administer the estate. The respondent failed to deposit these unearned fees into his attorney trust account. At the conclusion of the respondent's administration of the estate in May 2018, he unilaterally applied the remaining $168.65 in costs to his attorney's fees without seeking the approval or getting the approval from the beneficiaries. But most importantly, between August and October of 2018, the respondent withdrew $860 from the estate funds to pay his attorney's fees without seeking or obtaining the approval of the Orphans Court. In complete or clear violation of Estates and Trust Article, Section 7-602, the respondent failed to file a petition requesting that the estate pay his attorney's fees. The hearing judge also found that the respondent failed to create and maintain client matter records as required by the rules. The hearing judge found that the respondent's conduct was in violation of Rule 1.15, the safekeeping of property, and Maryland Rule 19-407 involving attorney trust account record keeping. Based upon the respondent's improper withdrawal of the estate funds alone, this court's prior case law supports petitioner's recommendation for an indefinite suspension in this matter. In Attorney Grievance Commission versus Kendrick, this court indefinitely suspended the attorney who, acting as serving as personal representative of the estate, accepted estate funds to pay her attorney's fees without seeking or obtaining approval from the Orphans Court. This court found that Kendrick violated rules 1.1, 1.3, 1.5, and 1.15, but the court found that her conduct was not a result of dishonesty or greed. In determining the appropriate sanction in that case, this court balanced the attorney's inability or refusal to accept the wrongful nature of her conduct with her lack of prior discipline. In this case, we have the exact opposite equation. Or calculation. The respondent has acknowledged much of his misconduct, but he has prior discipline for similar rule violations. In preparation for oral argument today, although it's not cited in our papers, I came across Attorney Grievance Commission versus Seaton, which is a case that can be found at 373 Maryland 409, that I think is particularly relevant to this court's analysis of the appropriate sanction in this case. In Seaton, the court indefinitely suspended the attorney with a right to reapply after 30 days when, as acting as attorney for the personal representative of the estate, the attorney deducted a $4,400 legal fee from estate funds without seeking or obtaining approval from the Orphans Court. In that matter, similar to the case here, there was no finding that the attorney hadn't earned the funds, just that the funds were improperly withdrawn. Similar to the case at hand, this court found that Seaton did not act dishonestly, was remorseful, and cooperative with bar counsel. Unlike the present case, Seaton had no prior discipline. A more serious sanction is warranted in this case because of the respondent's prior disciplinary history and the additional misconduct committed by the respondent that was not present and seated. In addition to the failure to safekeep client and estate funds in this matter, the hearing judge found—
Ms. Bolts, excuse me, I wanted to ask you the same question that Judge McDonald asked Mr. Kramer. What information is there in the record about the prior commission remand?
Sure, Your Honor. So the reprimand itself is one of petitioner's exhibits. Mr. Brooks received a reprimand in 2014 for violations of Rules 1.15 involving the failure to safekeep property, and then former Maryland Rules 16-607, the commingling of funds, and former Maryland Rule 16-609 involving prohibited transactions in an attorney trust account. Although the reprimand itself doesn't provide a whole lot of information in the language of the reprimand, it states that the respondent had corrected the procedures in his attorney trust account management that led to these rule violations, and because of that, the commission found that a reprimand was appropriate.
All right, so there doesn't appear to be much in the way of facts that would be available to us about that incident.
That's correct, Your Honor. In addition to the failure to safekeep client and estate funds in this matter, the hearing judge found that the respondent also failed to competently and diligently administer the estate in violation of Rules 1.1 and 1.3. The respondent failed to abide by the statutory provisions governing estates, including numerous errors on the Schedule B that was filed with the Register of Wills. The respondent failed to disperse estate assets in accordance with the statutory priority of claims, including failing to pay funeral expenses, and also provided the beneficiaries with incorrect advice regarding the payment of certain claims. The respondent filed a supplemental Schedule B with the Register of Wills that again included numerous errors, including improperly including his attorney's fees as expenses of administration. And finally, the respondent failed to provide a timely accounting of his fees to beneficiaries despite repeated requests to do so in violation of Rule 1.4. The respondent provided the first and only invoice to the beneficiaries 8 months after the representation began and only at the conclusion of the estate administration. In addition to the rule violations, the hearing judge found 2 aggravating factors. The first of which, the respondent has substantial experience in the practice of law, and the hearing judge found that much of that experience specifically was in estate administration. And then, as we've discussed a little bit, the respondent has a prior disciplinary history, that 2014 reprimand for similar rule violations. And as I've stated, despite the language of the reprimand stating that the respondent has corrected the procedures that led to those attorney trust account violations, the respondent has continued to mismanage his attorney trust account, including failing to maintain the proper records as required under the rules and failing to deposit unearned funds into his attorney trust account. Petitioner has taken 2 exceptions in this matter. The first of which, the petitioner accepts to the hearing judge's failure to find that the respondent's conduct violates Rule 8.4D, conduct prejudicial to the administration of justice. The hearing judge's factual findings clearly support a violation of this rule. This court has previously stated that where an attorney fails to provide competent and diligent representation to a client, along with failing to keep that client informed, that conduct also violates Rule 8.4D. Additionally, this court has found that where an attorney fails to deposit unearned fees into an attorney trust account and fails to properly manage the account, it's also a violation of 8.4D. Secondly, petitioner has accepted to the hearing judge's finding that the respondent's refund to the estate constituted mitigation. This court has repeatedly stated that timely, good faith efforts to make restitution constitute mitigation. In this matter, although the respondent did refund the estate the funds that he improperly withdrew to pay his attorney's fees, he did not do so until 2 years after those funds had been withdrawn. and less than 3 months prior to the hearing in this case. This court held recently in both Attorney Grievance Commission versus Miller and Attorney Grievance Commission versus Frank that a refund that comes long after the dispute with the client arises and because of or as a result of the disciplinary investigation, it's not timely good faith efforts to make restitution. However, with that said, regardless of whether this court sustains either one of petitioner's exceptions, our recommendation remains the same. One of the most crucial elements of the practice of law is the trust that is placed in an attorney to safeguard client or third-party funds. When that trust is eroded, even if done so negligently, as is the case here, it's a serious breach of the attorney's ethical obligations. And based on this serious violation in this case, in addition to the lack of competence and diligence found by the hearing judge and the respondent's prior discipline for similar rule violations, petitioner is asking that this court indefinitely suspend the respondent with the right to reapply after 6 months.
All right, thank you, Ms. Bolts. Let's make sure there are no pending questions. There appear to be none. Once again, thank you. We'll turn back to you, Mr. Kramer.
Thank you, Your Honor. In urging a suspension in this case, much less an indefinite suspension, Bar Counsel is looking at cases that are highly distinguishable from the facts of the case at bar. Let's just take a look at the actual facts of some of the cases that Bar Counsel has shared with you. Orutsky, a 1991 decision that resulted in this court's 3-year suspension from the practice of law. The attorney was dipping into the trust account for internal loans to meet cash demand. He apologized to the DC bar for doing it, but when Maryland charged him, suddenly he was trying to justify it. This court found that to be a duplicitous defense. No such facts here. The Tun case, 2012, an indefinite suspension for double billing multiple clients on 162 occasions. This was a panel counsel doing some criminal panel work for the Superior Court in DC. The person billed thousands of hours that he never provided, and the charges were fraud and lack of candor. DeCicco, a long history of misappropriation. Mr. DeCicco took the Fifth Amendment to curtail the criminal investigation. No such facts here, and my client was fully cooperative, answered all questions posed by Bar Counsel or anybody else in this case. The Kendrick case. The Kendrick case stands in sharp contrast with this one and should show why the sanction Bar Counsel wants is completely inappropriate. Here's a 2008 decision. Karen Kendrick botched an estate for close to 10 years. She was obstinate, using the court's language, in her refusal to return fees. She had an inability to accept responsibility for the mishandling of the estate, and this court felt that her attitude leaves much to be desired. No such attitude in this case. In this case, Mr. Brooks wanted to do the right thing, and when he was apprised of information from Bar Counsel showing that he made a mistake, he owned that mistake, and he made amends for it. No obstinance, no arrogance, nothing of the sort. The Miller case, which is the case cited by Bar Counsel, in which Bar Counsel questions the remedial measures undertaken by Mr. Brooks. In Miller, there was an overarching dishonesty undergirding a substantial number of violations. I'm quoting this court at 467 Maryland 176. The individual issued refunds begrudgingly and without remorse. He, quote, failed to atone, or she failed to atone for her actions, blamed her own client for her deceitful conduct. The case involved deceit, and the attorney appropriately was disbarred. These cases do not apply to Gary Brooks. They do not apply in this situation. The question really becomes for this court to answer: is it possible to deter others without disrupting this practice and the lives of the individuals Gary Brooks serves. Reprimands are the answer here, and they have been the answer in even more egregious cases. Take the case of Wyatt, 323 Maryland 36. It was a single instance of gross neglect of a legal matter. We have a single small estate here, that's true, but this court found that the attorney who neglected a workers' comp case for 56 months doing nothing, no facts like that here, obviously, warrants condemnation in the strongest terms. A reprimand was imposed in that instance. Weirs, commingling, failing to cooperate with bar counsel warranted a reprimand.
Mr. Kramer,
Case.
Mr.
Yes.
Kramer, the question that I have about this case, according to the hearing judge, since 2014, Mr. Brooks focused his practice on estates and trusts. And yet in this case, he appeared to make several errors about routine matters in a small estate. What assurance is there that a reprimand would be sufficient to protect the public where Mr. Brooks is concerned in the future? In other words, what changes or what remedial actions has he undertaken?
Well, he has a very good support network, including the chief judge of the Orphans Court of Baltimore City, number one, but number two, he himself is shaking his head over the mistake that he made in terms of the statutory order of priorities. One of the things that led to the confusion is that the estates and trusts article actually doesn't provide for petition for attorney's fees. So he considered them as expenses of the state administration. Granted, it was a mistake, but let's not take that out of context and make that what he's all about. If you look at this case, the estate plan that he devised for Errol Ellis really worked to the benefit of these legatees. He has also looked at his practice from soup to nuts, has made substantial changes in technology and otherwise. I think he's learned his lesson here. The question I would have for your honor, rhetorically, of course, is how would a suspension improve his practice? Presumably this court, I would hope this court is not seriously thinking that this person needs an indefinite suspension from the practice of law. We should throw the baby out with the bathwater here and completely terminate, have him put out, an out of business sign. I think that would be an overstep here and it would be unwarranted. But a suspension isn't going to improve his practice. A reprimand, the man has already learned his lesson. When he got information indicating that he made a mistake, he did something about it. And I think that that's what we want in an attorney, not somebody who never makes a mistake. It's a question of what do you do in response to a mistake? That's the key here. And that's something that shows character. And character is something that first and foremost, wanting to do the right thing and doing it. That's the kind of attorney we want serving the public. That's not an attorney that's going to be a danger to the public. Nobody got harmed in this case. Nobody even came close to being harmed in this case. And frankly, he did far more work than he ever got paid for, recognizing that some of that was his fault. He should have billed outside of the estate for that work. That's true. But it's not as if suspending him is suddenly going to improve his practice. I think that if this court were to engage or entertain any type of suspension, it would probably want to impose something similar to what it did in the Gallagher case. There was continuous, far more neglect than in this case, continuous neglect of an estate administration over several years that actually did harm the legatees. And there, this court imposed a 45-day suspension. This case doesn't involve anything quite that egregious, but a suspension of 45 days, 90 days, and indefinite, that certainly doesn't do anybody any good. I've never seen anybody who was suspended instead of reprimand come back from a suspension as an entirely new lawyer. We don't need an entirely new lawyer here. We have a good man. We have somebody who has served his clients well, Your Honor. And I think therefore, that is something that we know, this is not a person likely to reoffend. And I think that's important because we got to consider the mitigating factors and we have to consider the character of the person we're dealing with. If we were dealing with the character of someone like Ms. Kendrick, obstinate, refusing, I did nothing wrong, then an indefinite suspension certainly would be appropriate. I wouldn't want somebody like that dealing with the public. But I would want Gary Brooks to continue serving the Hurd family and so many others who really depend on him. He's serving a community that is underserved. He's an individual who's not on the take, not on the make. He's not trying to make a ton of money, and he doesn't, frankly. Sometimes he neglects his own billing to his own financial detriment. It's the good of the client that's important to him. And if we all consider the good of the client, then I think we need to keep him in service for the public. That's really the only way we are truly going to protect the public in this case. Thank you.